Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 20 in the list of AOR leading cases, and the case is titled as Technip SA versus SMS Holding Private Limited and others. Now, this is a case that relates to SEBI regulations of substantial acquisition of shares and takeover 1997, and it deals with what happens, what jurisdictional crisis occurs when a foreign company takeovers a foreign companies whose subsidiary is placed in India. All right, now in this case, before we move on to the decision, we need to understand what is happening in this case. Okay, now basically there is this one company, Technip. Okay, so we will look at the facts. Now there is one company, Technip. Okay, and there is one company, Coflexit. So Coflexip, what Coflexip is herein, Coflexip is both of these, Technip and Coflexip, both are based in France. These are French companies. But what is happening here? Coflexip has a subsidiary branch in India, which is CMEC. Okay, so CMEC is placed in India and it is subsidiary of the Coflexip. Now, basically, what happens? These are the placements. Okay, along with Technip, there is one other company, ISIS Management Bank, as well as IFP. Okay, IFP is another French company, and ISIS is its subsidiary. Okay, now these are some governmental bodies in France. Now, basically, what is happening? IFP is a shareholder both in Coflexip as well as in Technip. Okay, so IFP is a shareholder both in Technip and Coflexip, and Coflexip has a subsidiary in India by the name CMEC. So if we look at it, IFP's subsidiary is ISIS. Okay, and IFP has shareholding both in Technip and Coflexip. And Coflexip has a subsidiary, CMEC, which is placed in India. All right. Now, these four companies, these are all placed in France. Now, what happens? In July 2000, Technip acquires 29.68% shares in Coflexip. And by April 2001, Technip acquires Coflexip. And the Coflexip has somewhat 49.5% shareholding in CMEC. So ultimately, CMEC also gets acquired by Technip because there is a acquisition. All right. So this is the timeline of the order. Now what happens that SEBI regulations on acquisition of shares and takeover says that once majority shareholder is being taken over, the taking over acquiring company has to make a public offer for minority shareholders. Okay, minority shareholders. Now, in this case, it wasn't made, and the question arises that whether the acquisition was made in July 2000 or it was made in 2001 April. Okay, which date will prevail so as to decide that when the regulation will be triggered, when the application of regulation will be triggered. Okay, so this is basically the case which is herein. Now, aggrieved because herein the Technip, okay, Technip does not give the public order. Okay, so in this case, basically there are three litigations that are happening. One is happening before SEBI, another is happening before appellate tribunal SAT, and another is then the appeal is finally lying before the Supreme Court of India. Okay, now basically the question is that whether the acquisition triggers a mandatory public offer to be made under SEBI's 1997 taking over regulations, or what is the fate of it. Okay, now we are going to look into the decisions that are given by SEBI on this issue and also on the SAT. Okay. Now, basically, the main question is that did Technip acquisition of Coflexip triggers the requirement of public offer to be made under in the exercise of regulations, SEBI regulations 1997 that govern substantial acquisition of shares and takeovers. Okay. So the matter first goes before SEBI. Okay. SEBI says that first thing to decide that whether it is the July 2000 or April 2001 when acquisition happened. SEBI rules out in the favor of April 2001 because French laws will be applied here. And according to French laws, the date falling was April 2001 because the complete takeover was taken by April 2001 by Technic of Coflexip. So SEBI says that April 2001 will be the date of takeover, and therefore the public offer for minority shareholders shall be made in accordance with the date of April 2001. Then the SEBI is basically ordering, SEBI is saying that it is French law that will be applicable for the takeover, and it found that Coflexip has taken control in July 2001. Pardon me, it's July 2001 and April 2000. Okay. So it is saying that the control has been taken in July 2001 and it has been taken without public offer. So the SEBI, it directed Technip to make public announcement as required by the regulations of 1997 within 45 days and also told to pay 15% interest to shareholders for delayed announcement. Now this goes before appeal in SAT, which is Security Appellate Tribunal, Securities Appellate Tribunal. Security Appellate Tribunal reverses the finding of SEBI and holds that acquisition proceedings reckoned in April 2000, and that will be the relevant date. And the applicable law in the question is Indian law because it is a subsidiary placed in India, and therefore it also ordered to pay compensation to the shareholders for breach of condition of making a public order. Hence, violated by this order, the court, the Technip, it files an appeal before the Supreme Court of India. Okay. Now, the question that arises in this case is that what is the date and what law will apply, whether it will be the French law or it will be the Indian law. Now, the arguments that are advanced by SMS Holding and the respondents, basically, they are arguing that Technip gained indirect control in 2000 and it should have made a public offer under SEBI 2001. And whereas petitioner, the appellant herein is arguing that acquisition of control was completed only, full control was taken only in July 2001, and after which the CMEC was under the control of Technip. Therefore, any obligation that arises should arise from the date of July 2001 and not April 2000. Okay. So court is holding that both the companies, okay, once we look at Technip and we look at Coflexip, both are based in France, and therefore France will govern the question of when French law will govern the question of when Technip acquired control over Coflexip, as both were domiciled in France, and therefore according to French corporate law, control was legally and fully transferred only in July 2001 because in April 2000 only 29.68% shareholding was obtained. Now herein the respondents had made argument is that when Technip SA took acquisition of 29.68%, it was in collusion with IFP. Okay, it was in collusion with IFP, and therefore the it was in collusion with IFP. The IFP is another company that is based in France, and it was also contended. Okay, so the SMS Holding is also contending here that Technip and ISIS were acting in concert when Technip acquired a stake of 29.68%, and it was also alleged that ISIS shareholding together with Technip, gave de facto control of Coflexit much earlier in July 2001. So basically, they are saying that IFP, ISIS, and Technip are acting in concert. And if you take 29.68% stake that Technip acquired in April 2000 of Coflexip, and if you combine it with ISIS shareholding, IFP's shareholding together with Technip, it is giving de facto control of Coflexip uh, to Technic and ISIS much earlier than July 2001. Now the court refutes this contention, and court is saying that if ISIS was acting in concert with Technip, then the combined stake could have triggered the requirement, okay, in April 2000 and not July 2001. It's because they both were acquiring it, so there would have been a combined stake. So court is rejecting the argument that just because there are two companies which are shareholding in the acquired company, there is no evidence that proves the relationship between ISIS and Technip to jointly acquire control over Coflexip and de facto control. If you combine both the shares, that might be there, but the de jure control with Technip of Coflexip that has been acquired, it can only be attributed to be done in July 2001, and therefore Technip alone acquiring shares in 2000 April 2000 does not amount to acquiring control, and ISIS separate shareholding could not be attributed to Technip. Okay, now, basically what the court is holding in this case is that because the companies, okay, the parent companies Technip and Coflexip, they are being governed by the French law, so French law would be applicable until and unless it does not violate the public policy of India, and in this case there was no violation of public policy of India. The court is observing that because there is CMAC placed in India, CMAC is being the subsidiary of Coflexip, the acquiring company, which is Technip, has to abide by the mandatory compliances in SEBI regulation code. Okay, now Technip and court is holding here that French law, because both the companies are domiciled in France, French law will be applicable, but Indian compliance in accordance with Indian law has to be done. Therefore, the court said that. The court assailed SAT's decision, okay, the decision that was given by SAT appellate tribunal, that it's triggered in April 2000 and Indian law will apply. That decision was assailed down, and the court upheld SEBI's decision. Court held that number one, French law will be applicable, but Indian laws should be complied with. Indian compliances should be done with respect to CMEC. Okay, and it will be the compliances that are needed. That is, you need to make a mandatory public offer that needs to be made. That is one thing. And second thing, the court denied that ISIS and ISIS, IFP, and Technip SA were acting in concert. The allegation was denied, and therefore this was what was held in this decision given by the Supreme Court in the case of Technip SA versus SMS Holding. Okay, so this is the decision that has been given. I hope the issues are clear, because both the companies were domiciled in French law will have primacy and not the Indian law, but Indian compliances should be done with respect to CMEC. So courts ordered for uh, court in this case ordered that SEBI's decision, the first decision given by SEBI, should be upheld and overruled the SAT's decision that was used earlier. So SEBI said that it can only be triggered in July 2001, and therefore July 2001 was dated as the date of acquisition of Coflexip by Technip SA. Okay. Now the case is also emphasizing that public policy does not prevent Indian courts from applying for foreign law until and unless there is a violation of fundamental principles of Indian law. So here, French law was not in violation of public policy of India, and therefore French law was applied. So this particular case is crucial because it maintains that in cross-border dealings, timings, controls, etc. And jurisdiction matters a lot. Okay, so jurisdiction has to be decided accurately, and this is a precedent that that sheds light on extraterritorial impact of Indian takeover law as given in the SEBI regulations 1997. I hope this discussion was useful. Please stay tuned with Legal Darshan for more such videos. Thank you for watching. Have a great day.